Good afternoon, this is Jessica Orr with Beth Palma from Landcart. We will stand on our written testimony. Thank you.
Thank you. Next up is Department of Taxation with comments.
Good afternoon, Markey. On behalf of Isaac Choi and the Department of Taxation, the department would stand on its written testimony offering comments. I'll be happy to answer any questions you may have. Thank you.
Okay, thank you. And lastly, we have Tom Yamachika with comments.
Thank you, Vice Chair, Chair, members of the committee. Tom Yamachika from the Tax Foundation of Hawaii. I just wanted to clarify a couple of things in the written testimony. One is that the written testimony now references Rule 6 of the Rules of the Tax Appeal Court. That's a type, which it should reference Rule 3. Just to be clear, we're not really concerned about the $100 filing fee. We're more concerned about things of greater value, like deposition transcript costs, transcription of hearings, and other things that can cost thousands of dollars. I'd be happy to answer any questions.
Okay, thank you. Those are all the testifiers we have. Members, any questions? Seeing none, moving on to SB 412 relating to operating a vehicle under the influence of an intoxicant. First up, we have the Department of the Prosecuting Attorney in support.
And Chair, is this for Honolulu?
Yes.
Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the Prosecuting Attorney's Office in Honolulu. We will stand on our written testimony, at least to the current contents of Senate Bill 412. Department would note that in our testimony, we did propose a possible amendment. It basically adds the contents of House Bill 1379. This also deals with driving under the influence type issues, specifically implied consent law. The issue that's occurring, at least that is being addressed in House Bill 1379, is only occurring at this time on the Second Circuit, Maui County. However, as you know, eventually there is sometimes trickle down effect. So right now it is only on Second Circuit, but it is just clarifying that the use of implied consent is just another tool, and it does not preclude law enforcement from the use of a search warrant. I believe Brandon Siegel, who is the Maui County prosecuting attorney dealing with this issue, is also present, and we're both available to answer any questions. Thank you.
Okay, thank you. We do not have the prosecuting attorney for Maui signed up to testify. Next up is HPD in support.
Good afternoon, Chair. Lieutenant James Slater with the Honolulu Police Department's Traffic Division. We stand on our written testimony in support of this bill, available for any questions. Thank you.
Okay, thank you. That's all the testifiers. Members, any questions?
I have a question.
Yep, Chair. No.
For the Honolulu prosecuting attorney. Mark?
Yes, Chair.
I have some proposed amended language in front of me regarding this, and it is pursuant to a search warrant by a judge upon finding a probable cause supported by oath or affirmation or pursuant to any other basis permissible under the Constitution of the State of Hawaii and the laws of the state. For that second half, is that language necessary?
And Chair, as much as I would not like to give my chance to shine in the sun, I know Brandon Siegel is on online on this Zoom call. He is the deputy that is actually hearing this case in Maui County. If it's okay, I would love to defer to Brandon at this time to address that.
That'll be fine. Thank you.
Thank you.
Thank you, Chair. Brandon Siegel for the Maui County prosecutors. To address your question, essentially, and I'll keep it very brief, what that language is doing is essentially clarifying the legislator's intent when it enacted implied consent, to clarify that it did not intend to circumvent or supersede any other type of law enforcement or Fourth Amendment investigative tools, including but not limited to search warrants. The latter part of that language would also include other exceptions to the search warrant requirement. For example, exigent circumstances, which are rare occasions when there's an emergency where the police cannot obtain a warrant. For example, if the judge is just not available. But those are rare occasions. In general, 99% of the cases involve a search warrant. But the purpose of that additional language is to cover other recognized exceptions to the Fourth Amendment search and seizure requirement.
Okay, I think you know, some colleagues have expressed concerns about the broadness of that language. I guess, you know, does the language need to be so broad?
So I think that with regards to the concerns about being broad, what it's essentially saying is implied consent involves one area of the law, which is consent to a breath or blood alcohol search. And that implied consent is not intended to circumvent or supersede other exceptions to search and seizure law. And so to the extent that there's concerns about being broad, it's only limited to recognized exceptions under Hawaii Supreme Court case law and US Supreme Court case law. And that's always been the case since implied consent was enacted. What we're just trying to do is clarify what the intent was of the legislature through this amendment. So we're not adding any further exceptions to the rule. We're just clarifying what has always been the case, if that makes sense.
Okay, thank you very much.
Thank you.
Members, any other questions? All right, if not, we're moving on to SB 413, relating to violations of privacy. First up, we have Office of the Public Defender in opposition.
Hi, good afternoon, Chair, Vice Chair, members of the committee. I am Lee Hayakawa. The Office of the Public Defender respectfully opposes SB number 413. We will stand on our testimony, our written testimony, and I am available for questions. Thank you.
Thank you. Next up, we have Honolulu prosecutors in support.
Yes, Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the prosecuting attorneys in Honolulu. Just very briefly, just to add a little background of what types of cases we're actually dealing with. When we're talking about violation of privacy in the first and second, what we actually are talking about are the cases such as somebody taking an active step in either putting a video camera in an intimate place, such as a locker room, such as a bathroom, and tape recording these types of things. It also includes cases such as revenge porn. And the reason why the department believes that these types of offenses should not be deferral eligible is the long-lasting detrimental effects that it has on victims in the cases that we have in our cases. Whenever it gets posted up somewhere, you can't take that back. And so the victims in these cases would deal with that forever. Whereas the way that it is right now, if a defendant is granted a deferral, they have the opportunity to keep it off their record and not have to deal with that. Whereas our victims have to deal with that forever. So we are in support. It is part of our legislative package, and appreciate the committee for hearing this bill.
Okay, thank you. Last up, we have HPD in support.
Yes, good afternoon, Vice Chair, Chair, and members of the committee. I'm Captain Platt with the Honolulu Police Department. We stand in support of our written testimony in support of the bill. I would also like to add that we also echo the sentiments of the prosecutor's office, and that we find that the release or threat of these recordings can cause irreparable personal, professional, and financial harm. And as a result, they should not be eligible for deferrals. Thank you.
Thank you. Members, any questions? Rep. Nakamura.
This is for the prosecutor. My question is, in the case that you described, where someone inappropriately videotapes someone, what would be the crime, and what would be the if found guilty, what would be the penalty?
And Rep, this is a Class C felony, and for violation of a second degree is a full misdemeanor. So it would be all the standard penalties that would be addressed in a Class C felony.
I see. And so I have a question for the public defender. You're saying that this, you're against this bill. Can you describe your reason for that, for being against adding this language?
Thank you for the question. The Office of the Public Defender opposes anything that takes discretion out of the hands of the judge. Having been on the front line at circuit court for many years, I've seen enough times where the judge actually expresses on the record that, I wish that, my hands weren't tied. I wish I could do something for you. Our position is every case is different. Every individual is different. Every offense is going to be different as well. And it's our position that discretion should be left in with the judge to make the right decision. Additionally, I'm not sure if this piece of legislation was submitted as in response to a sort of an inordinate amount of deferrals being granted on these types of cases, because that's not what I've been seeing. And I don't know if that's happening at all. But again, we think it should be left in the sound discretion of the sitting judge. Thank you.
The judge has the discretion.
I'm sorry?
Currently, the judge has discretion and can grant a
Deferral. Yes.
Do you just want to keep it as the status quo? Okay. Thank you.
Thank you.
Members, any other questions? Prosecutor's Office, I just want to follow up on Rep. Nakamura's questioning. The deference acceptance of guilty plea or no contest plea, can judges both accept or deny defendants the ability to use those currently?
Yes, judges can. Basically, what would happen is if an offense was deferral eligible, and the defendant didn't previously use a deferral in the past, they would make a motion for a deferral. If our office didn't feel like that was appropriate, we would object to the motion and express why we don't believe a deferral is appropriate in this case. And then the judge would make that final decision on whether the defendant would be granted a deferral in a case such as that's in front of them.
Okay, so the judge could accept or deny it as it is. So the discretion is with the court, like the public defender said currently.
The discretion is with the court.
Okay, thank you. All right, moving on to SB 630 SD1 relating to child support enforcement. Members, there are no testifiers present for this matter. So moving on to SB 548 SD1 relating to elections by mail. First up, we have the Office of Elections in support.
Thank you. The Office of Elections will stand on its written testimony in support and be happy to answer any questions.
Okay, thank you. Next up, we have City and County of Honolulu, Office of the City Clerk, Elections Division in support.
Aloha, Chair, Vice Chair, and members of the committee. The city supports SB 548, in particular those provisions relating to voter registration. The measure not only expands the window of opportunity for voters to engage the voter process, but also remedies the voter registration dead zone between the 30-day deadline and the start of in-person voting. We also appreciate the change to keep the online voter registration system open until Election Day. This would greatly enhance the city's ability to process these Election Day registrants when they show up at service centers. As it relates to service centers, the city recommends that the bill be amended to the language in House Bill 201, which creates a uniform statewide policy regarding the establishment of service centers. Doing so would provide all counties with the flexibility to right-size its operation, including the number and location of service centers, taking into account important factors like election metrics and available resources. Furthermore, the ability to open service centers with varying days would help administrators to utilize the locations that would be otherwise unavailable under existing law. Will be available for any questions. Thank you.
Yep, thank you. Next up, we have Common Cause Hawaii in support.
Good afternoon, Chair, Vice Chair, and members of the committee. We provided extensive comments, concerns, and suggested amendments to SB 548. We do stand in strong support of this bill. We especially support Section 3, which notifies persons who are on parole and probation about their voting rights. We also have some questions about Section 6 and the provisional ballot inserted language, given that we have same-day voter registration in Hawaii. We also have great concerns regarding the expansion of returning ballots by electronic means. This is not secure given this day and age, and how our ballots have been shown to be hacked when returning them by electronic means. We also have concerns regarding Section 23. While this does expand the number of voter service centers throughout the state, which we only had 8 during the last elections, we find that this provision of Section 23 shows that it only will provide most likely 2 for the county of Hawaii and 2 for Maui Island on election day. And so we suggest that more voter service centers be provided for election day for those islands. I know time is limited. We've provided extensive comments, so thank you very much for allowing me to testify in support of this measure, and I'm available for any questions. Thank you.
Okay, thank you. Good chance for me to remind testifiers that there is a 2-minute limit. Next up, we have the LGBT caucus of the Democratic Party of Hawaii in support.
Good afternoon. Happy Aloha Friday. Michael Goloyu on behalf of the LGBT caucus of the Democratic Party of Hawaii. We do stand in strong support of this bill. We also would like to point out that that not only do parolees have the right to vote, those waiting at OCCC or holding facilities before their trial have not lost their right to vote, and they should also be notified of that right under state law. We are glad to see that you're bringing precincts back, as they are very useful for parties to organize, as well as campaigns to make sure that they are able to reach their voters. So on that behalf, the LGBT caucus does support this bill, but we do have some of the same concerns that Common Cause does. So thank you for the opportunity. So mahalo and have a good day.
Yep, thank you. Next up, we have National Federation of the Blind of Hawaii in support.
Mr. Chair, James Gashel here representing National Federation of the Blind of Hawaii. And we are in strong support of this bill, particularly those provisions which relate to special needs voters. One of those provisions does have to do with electronic ballot return, which is already allowed by law, but the problem is you have to make a handwritten signature, which we are asking to have a means of electronic authentication in lieu of a handwritten signature, and the reasons are stated in our written testimony. And 5 other states already allow this. We think Hawaii also should. This has been supported by the Office of Elections, and we support the provision in SB 548 SD1, and mahalo for your concern and consideration.
Okay, thank you. Next up, we have a number of individuals. First up, we have Audrey Suga Nakagawa in support.
Yeah, good afternoon, Chairman Nakashima and members of the committee. I'm Audrey Suga Nakagawa. I am representing AARP. I'm the advocacy director, and AARP is in strong support of this bill. In particular, we are very much interested in Section 23 regarding the voter service centers. In this past 2020 election, we noted that there was long lines for people to stand at the centers to register to vote. And we know that for many of our older voters, it was geographically quite challenging for them if they lived in the windward side and having to go all the way out to Kapolei or to the town. And I can imagine that it was also the same for those on the neighbor islands. So, we strongly advocate for that. There's more voter centers that would make it more accessible for people. And so we thank you very much for this opportunity to support this bill. Thank you.
Okay, thank you. Next up, we have Katie Keim in support. Not present. All right, next up, we have Virgil Stinnett in support. All right, not present too. Dr. Anne Lemecki. Boy, we're on a roll here. Okay, not present also. Members, any questions? All right, hearing none. Moving on to SB 635, relating to elections. We have one testifier today, Campaign Spending Commission in support.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Gary Kam, and I'm here on behalf of the Campaign Spending Commission. The commission will stand on its written testimony in support.
Okay, thank you. Members, any questions? Seeing none, moving on to SB 891 SD2 relating to the Hawaiian Homes Commission Act. First up, we have, well, we only have one, VHHL with comments.
Good afternoon, Chair, Vice Chair. The department stands on its testimony with comments. There are a number of sections that we feel is duplicative. However, there are a number of sections that we do support. Thank you.
Okay, thank you. Members, any questions? Rep. Nakamura.
Yes, for JHA, there are several sections of this bill that you state either you're already doing or is not necessary. And then LRB had a section that they were concerned about. But what are the sections that you believe are not necessary?
Section 1 of the bill, which talks about beneficiary, it basically takes our existing rule, administrative rule, and puts it into statute. So we don't feel that that is necessary.
So you recommend removal of section 1?
Yes, I do. Parts of section 2, let's see. For example, the first section that talks about reports, additional reports to require quarterly reporting. We at the Hawaiian Homes Commission actually have monthly reporting, and that can be found online. In our testimony is the link. Section 3 of the bill talks about expenditures, preparing annual reports related to Act 14. We release the annual report that is done for auditing purposes. That also can be reviewed at the site in our testimony with the link. And section 4, which talks about a loan servicing manual. We already have a loan servicing manual. Our loan officers have a lot more flexibility with our loan servicing manual than with the one that I believe is being proposed to take its place. And the commission, of course, is the one that ultimately has the decision-making authority on whether to grant additional opportunities for lessees who are in arrears to become compliant. Those are the main ones that we feel are unnecessary and redundant.
Okay, and then the other sections are all okay with you?
We support those other sections.
Okay, thank you very much.
Okay, members, any
Thank
other
you.
Chair.
Yes, Rep. Ward.
Thank you. Mr. Ayla, thank you for all you do. On the
Thank you.
loan servicing manual, I know it came up, and this is something that keeps track of what loans and what homesteaders are, what leases are out there. Why is it that you don't have your leases recorded at the Bureau of Conveyances, and it puts a huge burden on file keeping for you and the security of it, et cetera?
that is a requirement of the HUD-backed loans, FHA 247-184. That was a requirement of HUD coming into Hawaii and offering these loans on homestead lands.
And they said, don't use the state system, use your own system.
That is correct.
And the logic of that is, I mean, given some of the reports of files get lost and other things get confused, I would think turning it over to the state would be economical as well as probably equally professional. What was the logic that HUD said that was?
I wouldn't agree with you that files get lost. I think they get misplaced from time to time. We find them. The logic is that when we do any kind of action that has to do with the loan, whether it's taking action with outstanding balances or refinancing, the folks from HUD that oversee the program can come right to the department and inquire about anything directly, because it is part of something that is within the department's responsibility to maintain. So if there's any questions regarding our recording of our documents, that has never been an issue with anyone from HUD being able to access that information.
But it has come up as a big issue with conventional normal banks who would see that as a bit of an unusual or unorthodox. But the point being that the way
it doesn't take a long time for recording in our system to occur.
But isn't there a bill now that says you guys have got to digitize everything, which is even going to be a further burden on your DHL staff?
We actually are in the process we have been in the process for the last several years of digitizing much of the information. I believe the bill that is before the legislature is asking for, in addition to the digitizing, to be able to have the ability to sort and do other things with the information. Originally, that bill has been introduced for several years now. It was, I believe, introduced to assist our district managers with having access to the Oahu Central system. We have now made that system available to our district managers on the neighbor islands, and they have been trained on how to use it. So, you know, that issue for which I think this bill was originally introduced has been addressed.
Yeah, and generally you shouldn't feel bad because there's other places in the departments that, as indicated, are really far, far away from being up to speed. I guess the bottom line is, of the almost 10,000 leases, how many of those would have been digitized or available in electronic form of your almost 10,000 leases?
They are available to staff. They are available if they're subpoenaed. They are available to, certain portions of the files are available to the lessee and lessees' families if they have been authorized to view them. We are very cognizant of any personal information, the release of personal information without the proper request.
So what percent of your homestead leases would be digitized?
They have all been digitized with a small portion of additional documents to be added to the files. Because of the current Kalima case, we are required to keep many of the applicants' files and the lessees' files who are participating in the Kalima case separate and under close security or supervision.
You're referring to the Supreme Court case for the breach of trust. Is it the more recent Kalima case, I guess you're referring to?
Correct, but the case now is how I guess
how to make amends, so to speak.
Report.
Well,
topic here.
Yeah. So sorry, report. Basically, someone that's assigned by the the court to determine how the damages are to be paid, because there's many different categories of conditions that the court have identified as being a breach.
Okay. Thank you, Mr. Ayla. Thank you, Chair.
Okay, thank you, members.
Thank you.
We'll move on to SB 981 SD2 relating to the Office of Hawaiian Affairs. First up, we have the Campaign Spending Commission with comments.
Good afternoon again, Chair, Vice Chair, members of the committee. Gary Kam on behalf of the commission. The commission will stand on its written comments. Thank you.
Okay, thank you. Next up, we have Office of Election with comments.
Good afternoon. The Office of Elections will stand on its written testimony with comments.
Okay, thank you. Next up, we have Common Cause Hawaii with, in support.
Good afternoon, Chair, Vice Chair, members of the committee. We stand on our written testimony in support.
Okay, thank you. Last up, we have an individual, Lemomi Khan, in support.
Yes, aloha. Good afternoon, Chair Nakashima, Vice Chair Matayoshi, and members of the Committee on Judiciary and Hawaiian Affairs. I'm here to advocate passage of Senate Bill 981 SD2. In my written testimony, I provided a summary of OHA elections held since 2014. My review of the OHA elections and campaign spending reports validated the need for this legislative measure. Most candidates elected over the years had last names beginning with A, and with few exceptions, winning candidates spent in most cases over $10,000. Remembering though that this is a statewide race. If not for the challenges imposed by OHA, I would be advocating for more public funds for the OHA elections than what is contained in this bill. May I ask that you also note that by the testimony I gave, I do not mean to imply that the candidates who won didn't deserve to win, but rather to make the case of erasing the appearance of any system favoritism and in support of increased funding and raising opportunities for those with limited financial resources so that they can better compete and campaign. I think the question also begs, though, why the random listing only of candidates for the OHA elections and not all elections? While I think this is a good question, I likewise see the random listing as proposed by this legislation as advancing the fairness of the OHA elections and would hope that other elections would eventually follow. Thank you for the opportunity to provide comments today on this legislation. Aloha.
Thank you. Members, any comment or any questions? Rep. Nakamura.
Yes, I have a question for the Campaign Spending Commission. I wanted to find out, in your testimony, you talk about that this bill would increase the amount from 1,500 to 24,900. And I wanted to find out what is the source of these funds and do we have enough to support this in the current funds with current funds available?
Yeah, so the source of the funds are the tax checkoff that the Hawaii residents can do when they fill out their income tax. Any sheets that are forfeited to the state goes into that fund also. And in my testimony, in our testimony, we do indicate that given the past history of the offices, that the fund, the balance in the fund is enough to cover any anticipated increase for candidates receiving public funding running in OHA races.
Okay, thank you. I also, sorry, I have a question for Scott Nago as well. Mr. Nago, I wanted to find out doing the random How would you do the random selection?
So what we would do is we would put all 26 letters in a box, pick a letter, and whatever letter we pick, that would be the first letter, and it would be alphabetized after that. Also, I'd like to note that the randomization of the alphabets would only apply to the first letter in the last name, not necessarily the second letter.
Okay. And then there was comment from OHA saying that this process, if adopted, should be across the board. Do you agree with that?
That's certainly up to the legislature to decide. I do know when you start to get into races where there are only two candidates in a lot of general elections, sometimes randomization doesn't necessarily work out because it's just two candidates.
Yeah, I know with the Kauai County Council race, which is a at-large race, this is also
Correct.
an issue.
Yes.
Thank you.
Okay, members, any other questions? If not, let's move on to SB 1042 ST1 relating to covered offender registration. We have one testifier today, the Attorney General's in support.
And good afternoon, Chair Nakashima, members of the committee. I'm Deputy Attorney General Amy Murakami for this Department of the Attorney General. The department supports this bill. The purpose of this bill is to create a clear requirement that anyone who resides in Hawaii or maintains a residence in Hawaii or remains in Hawaii for more than 10 days or for an aggregate period of 30 days in one calendar year and who has been designated as a covered offender, sex offender, offender against minors, or any other sexual offender designation in another state and is required to register in that state or would be subject to registration in that state if they were residing in that state. Those people must register as a covered offender in the state of Hawaii. The bill also clarifies how this person who is registering under this requirement may petition to terminate registration after a minimum of 10 years. And this bill creates a clear requirement and is consistent with the purpose and intent of covered offender registration and is necessary for public safety. We respectfully ask this committee to pass this bill. Thank you.
Thank you. That's the only testifier we have today. Members, any questions? Report.
To the testifier, I assume that this was already the case. How does it compare to other states on the mainland and their need to register sex offenders, such as this bill indicates? 10 days, 30 days, residence, etc. What do the other states require in terms of registration?
I do not have the statistics on the other states. Every state has a different covered offender registration requirements.
Okay, thank you. Thank you, Chair.
Okay, thank you, members. Any other questions? If not, we'll move on to SB 828 relating to divorce. First up, we have the judiciary with comments.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Judge Jessie Hall, and the Family Court stands on its written testimony and available for any questions.
Thank you. Next up, we have the Hawaii State Coalition Against Domestic Violence in support.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, and committee members. I'm Angie Mercado, the Executive Director of the Hawaii State Coalition Against Domestic Violence. I do have one correction for my testimony. In the third paragraph, it should say grant instead of file for divorce. Otherwise, we do stand on our testimony as written in support for this measure. And I'm available for any questions you may have. Thank you.
Okay, thank you. That's all the testifiers we have on this measure. Members, any questions? Right, seeing none, moving on to SB 151 relating to the statewide traffic code. First up, we have Department of Transportation in support.
Good afternoon, Chair, Vice Chair, and members. The State Department of Transportation stands on its written testimony and support. We're also available for questions. Thank you.
Thank you. Next up, we have Honolulu prosecutors in support.
And Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the Prosecuting Attorney's Office, Honolulu. We stand on our written testimony and support. Thank the committee for hearing this bill.
Okay, thank you. Last up, we have HPD in support.
Yeah, good afternoon, Lieutenant James Slater, Honolulu Police Department's Traffic Division. We stand by our written testimony in support of this bill. Available for any questions. Thank you.
Thank you. Thank you. Members, that's all the testifiers we have. Any questions? Okay, seeing none, moving on to SB 294 SD1 relating to property forfeiture. First up, we have Office of the Public Defender in support.
Good afternoon, Chair, Vice Chair, members of the committee. My name is James Tobin with the Office of the Public Defender. The office stands on its written testimony in support of this bill. And we're available for any questions later.
Thank you. Next up, we have DLNR in opposition.
Yes, good afternoon, Chair and members of the committee. Jason Redula for DLNR. The department stands on its written testimony in opposition. Thank you.
Thank you. Next up, we have AG's office in opposition.
Good afternoon, Chairman Nakashima, members of the committee. My name is Gary Sanaga, Deputy Attorney General, here to testify on behalf of the department. We have submitted written testimony, but to summarize, we're asking that the bill be held because requiring a felony conviction of the property owner will essentially undermine the very purpose of the forfeiture law. And this purpose is the ability of law enforcement to go after property separately and apart from the person that committed the crime. And it is this ability that makes it a highly effective tool in taking out the profit out of criminal activity. It becomes a strong deterrent and ultimately protects the public. Hawaii has historically carried out the forfeiture law without the abuses and exploitation and corruption that has been portrayed in the news and in studies. These abuses may have occurred in other states. And why this is true is because there are safeguards built in the law. For one, only property that is involved in covered offenses is subject to forfeiture. And second, police must have probable cause in order to seize the property, and it's the same kind of probable cause that they have to arrest somebody, put them in custody. And before any property is forfeited to the state, the police and the prosecutors must prove that the property was substantially connected to the crime. And of course, any innocent owner will have has always had the chance to challenge the forfeiture in court or through the AG's office. We want to ensure the committee that the AG is committed to ensuring the program is administered fairly and follows the law. And in fact, we have completed almost all of the recommendations that came out of the 2018 audit. If the bill is passed, it would make it more difficult for law enforcement to carry out and fulfill this important public policy. Thank you. We respectfully recommend this bill be held. Thank you.
Thank you. Next up, we have the Department of the Prosecuting Attorney, Honolulu, in opposition.
Good afternoon, Chair, Vice Chair, members of the committee, Deputy Prosecutor Tricia Nakamatsu here on behalf of the Department of Prosecuting Attorney, City and County of Honolulu. We are strongly opposed to this bill. You have our written testimony before you. In essence, we feel that this bill is basically attempting to merge civil and criminal law in a way that was never intended to do so. The civil law has its own set of standards of proof. Preponderance of the evidence is very commonly used. Even in Hawaii, our civil courts, our administrative boards and commissions, they use a lot of them use preponderance of the evidence. And if the concern is that in these civil asset forfeiture cases, property shouldn't be forfeited, or people shouldn't have to give up their property because of this supposedly low preponderance of the evidence standard, that is actually the standard that that's used in these cases, lots and lots of cases throughout the state. And it could be losing their licenses, professional licenses, their actual property. We list a number of different commissions, boards, departments who hold hearings, and people can stand to lose their livelihoods, their property, assets, based on this preponderance of the evidence standard. And that's because it is a civil standard, which is completely separate from criminal justice standards. Beyond a reasonable doubt is as high as it is because in those cases, people stand to lose their liberty. You can literally lock them up, put them in jail, and they have essentially no choice at that point about their own freedom of movement. That is why beyond a reasonable doubt is the highest standard in the land, and that is why it is used in criminal cases. It's not even used in other types of cases that our office handles, like traffic infractions or other types of low-level offenses.
2 minutes. Could you conclude your testimony and summarize?
Oh, I'm sorry. Yes, just to, as a final note, we note that some of the covered offenses are promoting the sex trafficking, drug cases, very serious cases. If you have a property owner, for example, who is not in the country, you would never be able to get them, ever. And that's just something to think about. We appreciate the time. We're available for questions. Thank you.
All right, thank you. Next up, we have HPD in opposition.
Yes, Philip Johnson for the Honolulu Police Department. Stand on our written testimony in opposition and available for questions. Thank you.
Thank you. Next up, we have Community Alliance on Prisons in support. Not present. Next up, we have Common Cause Hawaii in support.
Good afternoon, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause, and we stand on our testimony in support of this bill. Thank you.
Good, thank you. Next up, we have Drug Policy Forum of Hawaii in support. Not present. Next up, we have the ACLU of Hawaii in support.
Good afternoon, Chair, Vice Chair, members of the committee. Mandy Fernandez on behalf of the ACLU Hawaii. We strongly support this measure. Civil asset forfeiture is a civil action brought against a piece of property on the premise that the property is guilty of a crime. It became popular a few decades ago as part of the failed war on drugs. The purpose of civil asset forfeiture is supposed to be to disable criminal operations. Instead, it is often used as a way to pad the budgets of police and prosecutors with little oversight or accountability. Hawaii's asset forfeiture law is actually considered to be one of the worst in the nation. We have a low burden of proof. Hardly anyone gets their day in court before their property is forfeited or sold off by the state. And if they do go to court, it is at their own expense. We do not require that the crime is even tied to the property owner. In fact, a 2018 report by the state auditor found that in over a quarter of all forfeitures, they were done with when there were not even corresponding criminal charges. So not only was the property owner not convicted of a crime, but nobody was even charged with a crime that was connected to that civil forfeiture. This is often called policing for profit because law enforcement has a very strong and clear incentive to seize valuable property that is only tenuously connected to a crime. So under Hawaii law, the police, who are usually the initial seizing agency, they get 25% of the proceeds. Prosecutors get 25% of the proceeds, and then 50% goes into the criminal forfeiture fund. This measure is necessary to protect innocent property owners by requiring that forfeitures only go through after there has been a felony conviction of the property owner, and it mitigates the profit incentive by directing all proceeds to the general fund. So police are doing this because it will actually disable criminal operations, not because they'll profit from it. That being said, police will still be able to seize property, so that initial purpose of disabling criminal operations.
Are we still alive? Yeah.
Well, the timer cut her off. You reached your 2 minutes.
That does happen to be 2 minutes, but I think we lost your connection. Andy, if you can hear us, you are frozen on our screens. Oh, that's 2 minutes anyway. Members, any questions? We're board.
To the frozen person, no. Actually, to HPD. The term policing for profit, do you have any response to that in any general or specific ways? Some of the things that seem to rise to the level of it is all about Benjamins and money rather than about justice. HPD, are you still there?
Yes, sir, I'm here. I'm sorry, I could hardly hear you.
Oh,
I apologize.
I don't want to say accusation, the description where this is policing for profit. Do you have any response to that, or any way that you can say in some instances it looked like it, but it wasn't? I'm trying to see what the...
I would disagree with that. our whole intent of enforcing the law is to disrupt crime, stop crime, seize assets of crime. I don't know what more to say about that.
No, that's fine. Thank you very much. I have for the public defender. What are some of the horror stories that you kind of implied, if this bill didn't pass, would continue to occur? What are some of the downsides that you see specifically? Are you still there, public defender?
I'm sorry.
You want me to repeat the question?
Yes, please. Thank you very much. I apologize.
Some of the horror stories that are implied by your testimony that if this bill didn't pass would continue to be proliferating. What are some of the worst case scenarios that you make it sound like this bill is going to be hurting or denying or somehow disrupting the individual as well as property rights? Give me some horror stories is basically the question.
I don't have any personal horror stories, but I do. Hang on one sec. Oh, let me put on my video here. I apologize. Here, basically what they're trying to do is they're going to take property away when we don't know whether the person's guilty or not. And that's just wrong. And I know it's not locking him in jail and a whole bit, but we're still, because when we have a situation, let's just say the potential here is that we have some kid, adult child, doing drugs or selling drugs from a parent's home or using a car or whatever it may be, that property is going to get taken away. And it doesn't even belong to the, it's because it's been used by the adult defendant child.
Perfect. How many times has that happened?
I don't have statistics on this, but that's what this law allows it to do. It's basically to take away property from people that are not found guilty. And I think the study shows that there have been a number of times where property has been taken away and the cases have never gone to court or that there's no conviction. And that's just wrong.
Okay, thank you for your testimony. Thank you, Chair.
Okay, thank you. Members, any other questions? Now we'll move on to our last bill of the day, SB 715 SD2, relating to the issuance of special purpose revenue bonds to assist Pueo Development LLC. We have two testifiers today, DHHL in support. Not on? Okay, last we have Bob Hall from Pueo Development LLC in support.
Hello, Chair, Vice Chair, Bob Hall. I stand on my written testimony in support of this measure with amendments that mirror House Companion Bill HB 776 HD1, which House just recently crossed over to Senate. I'm available for questions. Thank you.
Members, any questions? Report.
Very brief. Mr. Hall, this is a special purpose revenue bond for $80 million. How many houses do you suspect or would project would be built with that revenue bond?
We don't have a current projection on the total amount of houses to be developed. The special purpose revenue bond will be used to leverage the total project cost, which includes infrastructure as well. But I would rough guess at least about 150.
150. How many acres of infrastructure does that imply then? When you say it's for infrastructure?
So the Department of Hawaiian Homelands, and we're working with them right now. If you notice in their testimony, the Waiahuli Homestead Association was granted a right of entry to access to about 150 acres of land. It is currently raw land adjoining Waiahuli Hawaiian Homestead up in Kula, Maui. And we're looking to do, we're doing a conceptual development right now on what that land can bear, including streets and infrastructure, rough numbers between 100 and 150 homes on that parcel.
Godspeed if you get this passed, that you build them fast, efficiently, and they are very much needed. Thank you. Thank you, Chair.
Okay, thank
Mahalo
you
for your support. Thank you.
All right, seeing none, that is it. We are going to be deferring decision-making on these matters until Tuesday, 2 p.m. in room 325. Hearing is adjourned.